So the executive must determine what those budgets are. But of course, there must be commonsensical negotiations and discussions to ensure that the agencies get sufficient money to perform their functions. We have no difficulty with that. The judge also said that when the budget comes from these agencies, it must go directly to the Ministry of Finance. Again, we have no difficulty with that. The judge also ruled that when the monies are disbursed by the Parliament, it must go straight to the agencies. We are doing that. We have done that in relation to 2021.
That was Attorney General Anil Nandlall reacting to Monday's ruling on budgeting for constitutional agencies. The matter was taken to court by way of a fixed date application in February 2021 by the APNU-AFC coalition after the government passed several amendments to the act which reversed revisions made in 2015 to the process of approving sums for constitutional agencies. Those amendments passed by the coalition in 2015 insisted on scrutiny of the budget for the agencies and saw agency heads having to present the budget directly and separately to the National Assembly instead of what was obtained prior, where the finance minister made the presentation in its entirety. Nandlall said the judgment was essential in favor of all the amendments made by the PPPC government and also declared that the amendments made in 2015, which took away the responsibility from the finance minister, was unconstitutional. However, the government amendment, which lists those agencies in a schedule, was wrong and must be changed. But Nandlall argued that the agencies were part of the schedule historically, and that is the way the PPP had inherited the system. The changes, as directed by the court, will be made, he said.
And the other important component of the ruling is that the budget of these agencies must not be part of the Appropriation Act. So there's going to be a slight procedural change. That is what the judge is suggesting. Just put it in another document because it's a direct charge. In any event, when it forms part of the Appropriation Act, it doesn't require, you don't vote on these items in the National Assembly because they constitute a direct charge. But they were part of the Appropriation Act historically. We inherited that system from, I suppose, Great Britain during the colonial days.
The court made no coercive orders against the state, and the court stated that there would be no order as to cost in light of the significant public interest nature of the action.
The decision is a good decision. It did not find any wrongdoing in the budgetary process or any intent by the government to control the independent constitutional agencies. I think that it asserted certain constitutional realities. It identified that there are loopholes in the system, which we will have to promulgate either regulations or legislation to correct.
The application was filed by opposition parliamentarians Roysdale Ford on behalf of his colleague parliamentarians Ganesh Mahaipal and Coretta MacDonald, along with other opposition-aligned heads of a few constitutional agencies. For the newsroom, Kurt Campbell.